So, welcome everyone to today's Berkeley Center for Law and Technology's Expert Series webcast. And today we bring you a true expert with Professor Pam Samuelson. It's hard to introduce Pam. If you're looking at a copyright case and you came to this and you didn't know Pam, you're probably a patent attorney that's hiding from the copyright world. If you look at the body of work when we Pam through the years, the first thing I wanted when this case came out was somebody to explain what it really meant and somebody to explain, is it really going to have any impact or no impact at all? So Pam, thank you so much for giving us your time. I know you're just getting back in town, and I hate to bother people when they immediately get off a plane, but you did this for us because of the timing. So thank you. And with that, I am gonna turn this over to you to tell us what the Supreme Court's recent ruling in the copyright world really means.
Okay, well, thanks very much, Wayne, for the opportunity to do this talk. And I thought I'd sort of give you an overview about where we're going to go. So I'll start with just refreshing people's memory about what the nature of the claims were in the lower courts. There were two issues raised by Cox in its cert petition, and the court granted both of them, while also denying the cross petition by Sony. I'll emphasize a few of the notable issues that were raised in the merits briefs and also in some of the amicus briefs, because I think this is one of those cases where amicus briefs really did make a difference. I'll talk about a little why the oral argument did not go as well for Sony as it had hoped. And then we see that a unanimous Supreme Court reversed the Fourth Circuit on the secondary liability standard. And there's an interesting concurrence that Justice Sotomayor wrote for herself and Justice Jackson. And I'll give you a little bit of highlight on that. And then we'll kind of end with some implications of the Cox decision for other IP cases. And the answer to the question you raised, Wayne, at the beginning, is this going to have any impact? Boy, this is going to have a big impact in secondary liability cases. Exactly how much remains to be seen, but by throwing out the material contribution with knowledge basis for saying that there's secondary copyright liability, Supreme Court just threw that one out. And so a lot of the cases that are out there involving secondary liability under contributory infringement, they're going to have to be rethought, and some of them actually might not result in some the same outcome as before the Sony case was decided. So that's where we're going. Sony Music, along with many other sound recording and music owner copyrights, sued Cox for contributory and vicarious infringement claims. Although Cox is a broadband provider, and generally speaking, would seem like it qualified for the safe harbor of Section 512A. However, a lower court had basically decided that 512A safe harbor didn't apply at all. And so we were left with trying to make decisions about contributory and vicarious liability based on common law standards that have evolved in the copyright case law. So on the contributory theory, what Sony was saying was that Cox was continuing to provide broadband services to accounts whose users had engaged in multiple copyright infringement, and they failed to terminate those repeat infringers, and that the failure to terminate and the continued service were knowing material contributions to those users' infringements. And on the vicarious claim, the theory was that Cox had the ability to supervise and control users' infringement by, again, terminating their accounts, but it just didn't want to lose the revenue from customers who are engaged in copyright infringement. So it kind of was pretty lame about terminating any of the accounts of repeat infringers. Now, the case went to a jury, and the jury found liability under both contributory and vicarious infringement, and awarded $1 billion for willful infringement of something in the neighborhood of 10,000 infringements of particular works. Um, the case then went to the Fourth Circuit, and the Fourth Circuit affirmed the contributory infringement ruling, but reversed on the vicarious claim because Cox did not enjoy any direct financial benefit from users' infringement. So if some account actually infringed, it didn't get, Cox didn't get more money from the ones that were infringers as opposed to ones that just basically use the service. But because the $1 billion was predicated on two violations, not just one, the Fourth Circuit thought that it should go back down to the trial court for a retrial on the damages issue. So Cox petitioned for Supreme Court review and raised two questions. The first was whether the Fourth Circuit erred in holding that a service provider can be held liable for materially contributing to copyright infringement merely because that entity knew that people were using certain counts to infringe and did not terminate access. And there was no proof that the service provider affirmatively fostered infringement or otherwise intended to promote it. And so they were saying, you got to have more than material contribution with knowledge. You have to have some actual malfeasance to be contributorily liable. And the second issue was whether there was an error in holding that mere knowledge of another's direct infringement suffices to find willfulness under the statutory damage regime. So instead of being capped at $30,000 per infringed work because it was willful, it could have gone up to $150,000 per infringed work, but they didn't actually do 150. They only did more or less $100,000 per infringed work. And those were the two questions that were put to the court. And Sony cross petitioned, asking the court to say that vicarious liability doesn't require proof that the defendant derived a financial benefit from third-party acts of infringement. And again, the court granted the two from Cox and denied the one from Sony. So Cox's main arguments look like this. Providing a basic communications infrastructure to the general public should not constitute contributory infringement. Contributory infringement requires some proof of culpable conduct whose purpose is actually to foster infringement. Cox doesn't want its customers to infringe. It has terms of service rules that say don't engage in any copyright infringement. And because Sony and the other plaintiffs were sending lots and lots of notices, Cox actually started an anti-infringement program at its service. And so it sent warnings out, you've been detected. This account has been detected for having engaged in some infringement. Please don't do it again, and so forth. The one of the things that I think made a real big difference in this case was that quite a few of the accounts whose users were repeated infringers were institutions. So universities, barracks, military barracks, hospitals are examples of, institutions where somebody uses the hospital broadband service to engage in infringement. But if you terminate the access to the internet because of those because of the infringers, then a lot of really innocent people will be unable to enjoy the internet service that they count on. So I think that was a really important thing. And so, Cox basically also said, look, if this ruling is upheld, then we're just going to have to terminate lots and lots of people, and there are going to be lots of people who suffer from that, and that's just not fair. I didn't do anything wrong. I just provided a service, and some people misused it, and that's really too bad. And then they also wanted to argue that it's not willful contributory infringement unless Cox knew its own activity was unlawful, which they said we didn't. So Sony has a different story, obviously, to tell. It relied quite heavily on a Second Circuit Court of Appeals decision in the Gershwin case, uh, in which the court basically said that an entity can be held secondarily liable if it knows that it's materially contributing to infringement by others. Both the Grokster and the Sony decisions by the Supreme Court cite approvingly to the Gershwin decision. And the Gershwin decision was part of the kind of background secondary liability rules when the DMCA was enacted to provide safe harbors for certain types of online service providers. There was a jury verdict after 12 days of trial. And one of the things that really hurt Cox was that some of its staff basically characterized some of the accounts as habitual offenders. There were also liberal uses of the DMCA, so showed really contempt for copyright owners and their concerns. From the standpoint of Sony Music, the anti-infringement program was a joke. They didn't terminate until you had like got so many notices that that it was just ridiculous. Now, another one of the points that actually was pretty important in the oral argument was a concern about, the DMCA's safe harbors from liability for user infringement is dependent on all of the ISPs having repeat infringer policies and actually implementing them. And there's no incentive for a firm such as Cox to cooperate with copyright owners if the ISP can just basically sit back and sort of say, you sent me a bunch of notices, but I don't have to pay any attention to them. And so that's actually something that I think Paul Clement for Sony really emphasized quite a lot, and also argued that willful contributory infringement is appropriate when there is kind of reckless disregard of copyright owners' interests and just really not really trying to cooperate with copyright owners at all. Okay? Now, Cox actually attracted quite a few amici. Some of them were not very surprising. So other entities that actually provide broadband service, they were in there and basically said, "Hey, this is really terrible, and it's going to hurt really a lot." A number of the major platforms such as X, Google, Amazon, Microsoft, Mozilla, and Pinterest also filed some pretty strongly worded briefs. Several of the civil society organizations filed briefs. So ACLU and the Center for Democracy and Technology filed one. EFF, the Electronic Frontier Foundation, and the American Library Association filed one. Public Knowledge, and there were a few IP professors that also filed briefs. I'll say I wasn't one of them. I'm not a tort scholar, so the briefs were really written about tort law, and that's not what I do. The two briefs that I think were quite influential and a little surprising was the Solicitor General. Solicitor General supported Cox, saying that there was a need for culpable conduct that aims to facilitate that infringement. And the Solicitor General said there's no evidence that Cox was anything more than just indifferent about copyright and copyright infringement. And the Solicitor General looked to one of the Supreme Court's previous cases, decided only a couple of years ago, the Twitter versus Tomna case, which sought to hold Twitter and others of the major social media platforms liable for the deaths of some people by terrorist attacks, and there is a law that allows civil actions against those who substantially assist or aid and abet unlawful actions such as terrorist activity. But the Supreme Court said that there was no liability because there was no culpable conduct. All that Twitter did was provide a platform where some of the people who were terrorists could post things that they were interested in. And there was no causal link between anything that was posted on Twitter and the terrorist incidents that actually were the basis of the lawsuit. And so one of the things that the Solicitor General also said was that Cox's service to those accounts, especially the institutional accounts, they have substantial non-infringing uses. Now, this is actually the first time that there's been an argument that the substantial non-infringing use concept from the Sony Betamax case from 1984 had any application at all to an ongoing service provided by an entity such as Cox. So to basically come out in favor of Cox and basically say that Sony's victory should be reversed was a pretty big thing. Also, the Internet Society, which is a nonprofit organization that really tries to pay attention to policies that implicate people's ability to get access to the internet. The Internet Society basically said this ruling in favor of Sony Music is one that imperils public access to the internet, and that therefore that the Fourth Circuit decision should be overturned. Now, Sony basically also had some amici, and you won't be surprised to hear that some of the major copyright organizations, such as the Motion Picture Association, the Copyright Alliance, the National Music Publishers Association, the Recording Industry Association, Sound Exchange, they all filed briefs, and they filed briefs separately. So I'm sure they had coordination, and I'll emphasize this and you emphasize that. But there was also a brief by some former members of Congress and some former senior Copyright Office staff who basically also weighed in support of Sony. And there were some other briefs in the case, including two briefs by intellectual property scholars. So there were briefs on both sides from the scholarly community. At oral argument, one thing that was really significant and it came up over and over again is that the 1976 Copyright Act doesn't contain, as the patent statute and as the trademark statute has, secondary liability standards. The textualists among the conservatives were kind of concerned about that, right? If it's not in the statute, where do we go? And so that suggested that they wanted to take a narrow view of secondary liability because it's not in the statute. Now, because both the Sony and the Grokster cases borrowed secondary liability standards from patent law, there was talk about, well, we've previously recognized that copyright can draw upon patent analogies. And so that's actually a basis for saying maybe we should only go as far as the patent statute would go in terms of contributory infringement. And so that was kind of in the oral argument. Now, again, the Sony was able to kind of make some headway about the sort of no incentive to cooperate with copyright owners to reduce infringement if you just basically don't have any liability at all. And they wanted to say, that you should make an adverse inference about culpability when they don't qualify for the safe harbor. And Section 512L actually has a provision that says no adverse inference of liability should be drawn from the failure to qualify for the safe harbor. Even if you have a no or a weak repeat infringer policy, it doesn't mean you're automatically liable. Okay, so there was talk about what is the implication of 512L, and the final opinion basically says you shouldn't draw any adverse consequences from the failure to qualify for the safe harbor. So that was something that really tipped things in favor of Cox. Now, there is one provision in the 1976 Act that provides at least some basis for secondary liability. If you kind of go back to Section 106, which is the exclusive rights provision, what you see is that authors are granted the right to do or to authorize reproductions of their works and copies, making of derivative works, distribution of copies, and public performances and public displays. So the to authorize language is a basis for some secondary liability, but I think you can see that if authorization is the basis and the only one in the statute, Cox wins because nobody's arguing that Cox authorized any subscribers to engage in copyright infringement. And then if Sony has to rely on the patent standard, it looks like Cox wins there too. And that's what the Supreme Court ended up holding. So you have actually 271B, which in the Sony case, in the Grokster case, the Supreme Court borrowed the act of inducement secondary liability in the Grokster case, and because Grokster had actively induced infringement, it could be held liable for inducement. And in Sony, the court basically borrowed 271C, which is the contributory infringement standard. If someone makes a product that and provides it to the public that lacks substantial non-infringing uses, and again, no one is arguing that Cox induced infringement. And as the Solicitor General noted, its service has a lot of substantial non-infringing uses. So under the patent standard, Cox wins. Now, under general common law rules, again, the Twitter versus Tomna case was another one where there was talk about aiding and abetting liability in the Twitter case. That contributory infringement is just another type of aiding and abetting. But the Twitter case basically says you have to show that the defendant engaged in purposeful, culpable conduct providing substantial assistance to someone who is about to do something illegal with the intent to facilitate that wrongdoing. And the court ordered the dismissal of the Tomnick case against Twitter because there was insufficient evidence of that. Now, the only way that Sony Music could win would be for the Supreme Court to basically say, hey, the sort of the general tort rules about secondary liability, they don't apply when it's copyright. Copyright has its own special rule and material contribution with knowledge that you're contributing to infringement. That's enough. Okay, so that's the case as it was pending before the court. Now, pretty much the first thing that the Cox opinion says, under our precedents, a company is not liable as a copyright infringer for merely providing a service to the general public with knowledge that it will be used by some to infringe copyrights. Period. Okay? Again, noting that the 1976 Act doesn't have a secondary liability provision, the way that trademark and patent law have. They were willing to go to the patent standards again because we had done it before. But direct quote here, we are loath to expand liability beyond those precedents. So The defendant must either have induced infringement or specially tailored its product or service to facilitate infringement to be indirectly liable under the patent-like standards. And the court says that Sony just misunderstood the safe harbor provision because it creates a new defense. It doesn't create a new basis for liability. And so the failure to terminate just doesn't cut it, okay, as a basis. Now, Justice Sotomayor wrote a concurrence for herself and for Justice Jackson. And she basically said, look, there's no reason to limit secondary liability just to the patent contributory and the patent inducement. There are other bases for holding secondary liability, such as the aiding and abetting provision that was discussed in the Twitter versus Tomna case. But the Sotomayor agreed that Cox is not indirectly liable for users' infringements because it didn't have any intent to facilitate that. Supplying internet service is not culpable conduct. Cox didn't aid any specific infringements, and receiving notices of some infringement doesn't say who, in fact, the infringer was, especially if the subscriber is an institution, not an individual. And indifference to infringement is just insufficient. So, the DMCA just didn't do it with the Supreme Court, even if it kind of like flew pretty high before the jury. And the court, this concurrence actually worried that the majority opinion would dismantle incentives for ISPs to cooperate with copyright owners. But that concern didn't animate any of the majority opinion. So she's just flagging this issue, and we'll see whether Congress decides to do something. Now, I'm sure that some of you out there are sort of saying, what's the implications? I think there are a number of cases that involve claims of contributory infringement. So Napster, for example, I think it can be reinterpreted as an active inducement case. The Perfect 10 versus Amazon case out of the Ninth Circuit Court of Appeals said that there was contributory liability if you failed to take simple measures to prevent infringement. I think that's no longer going to be a viable precedent. I think that it doesn't match up with the kind of the patent standards that the court endorsed. And it's not clear what it's going to mean for vicarious infringement. I think because they emphasize so much that there needs to be culpable conduct and there needs to be sort of an intent to sort of facilitate and help infringement to happen, I have a feeling that some of the vicarious cases are going to fall also. Now, some of you out there might be concerned about how is this going to affect patent law and also trademark law, and I think there are going to be some implications there too. I thought that the court might actually hold on to the Cox decision until after the Hickma case came down. That's a patent inducement case where the Court of Appeals for the Federal Circuit ruled in favor of the inducement claim being made in that case, and the Solicitor General came in support of Hickma's appeal, and again, the Supreme Court granted cert on that issue. So stay tuned to the oral argument, which I think is happening on April 29th, and we'll be able to tell quite a bit about how the court's thinking about patent inducement by listening to the oral argument there. Inwood Labs is the Supreme Court opinion that says that if a manufacturer or distributor continues to supply products to someone that they know or have reason to know is engaging in trademark infringement, they can be held contributorily liable for any harm that happens as a result. Is that going to be overturned too? Again, I think the court wants to do something to kind of like cut back on secondary liability. And so we'll see what happens with that, but that's my prediction. So With that, Wayne, I think it's time for you to come back on and do a little bit of colloquy, and then I'm going to go home.
Well, as always, wonderful and impressive. So, look, my major question is going to be, what does this really mean for the future activities of your content creators, your folks in Hollywood, your music creators? What's their next step to try to cut back on infringement?
So, again, the court didn't say anything about vicarious. And so there may be fact situations where vicarious claims are more plausible than it was. I mean, I think you can see that what Cox did, right? It has 6 million customers. It just provides broadband service, right? It can't tell what the hospital or the university is doing with that, or which people are doing the infringement. So, it didn't have any control. Unlike the sort of the general speaking, the platforms that host content, they can't take it down, right? They don't have any control over that stuff. So I think that's another aggravating consideration. Other fact patterns might have different circumstances, but the unfortunate thing for the Hollywood right now is that we have a pretty dysfunctional Congress. And so their next step might very well be to say, "Hey, let's amend the Copyright Act to add secondary liability standards for copyright, and let's read that material contribution with knowledge standard that had been kind of pretty well accepted in the courts since the Second Circuit decision in 1971." And lots of the briefs said, "Oh, that's been standard rule for a really long time."
Well, I wish them luck getting anything through Congress in the next several years. So,
Yeah.
well, the other thing, that the takeaway from me, the trial lawyer in me, points to the fact that all it takes is a couple of callous emails to end up with $1 billion verdict in something like this. And so
Yep.
that's that's either a trial lawyer's dream or nightmare when you found that
F
those emails. Yeah,
FEMCA.
yeah.
Not
And
going well
so
with the jury.
and I do hear people and complain about the jury's getting it wrong. It's just the trial lawyers got it right, and people sending bad emails is always going to be a problem. And with
Yep.
the amount of discovery we do in a company that large, you're always going to be at a disadvantage for a few rogue employees sending out those kinds of emails. So it's interesting how a couple of callous emails gets us to the Supreme Court.
Yep. And it's important to sort of understand that there are other cases pending against some of the other broadband providers. And so that's why many of them were filing amicus briefs saying, "Oh, change the standard." And they have a pretty powerful lobby too. So even if Hollywood tries to go and sort of say, we want this standard, there's going to be some pushback because there's some companies that actually have some clout too.
Well, Pam, thank you. I appreciate your time, and we'll get you home from here.
Okay, thanks. Bye bye.